Inside podcast. I am Annkitta Jagtap. Today, we are dismantling a legal myth that has fueled thousands of lawsuits across India. The idea that a long-term tenant can eventually claim ownership of a property. The passage of time is not a conveyor belt that moves you from being a lessee to being a proprietor. Today, we will deconstruct the statutes from the Transfer of the Property Act to the latest 2025 Supreme Court's mandate to explain why the landlord's right to reversion is absolute and why a tenant, regardless of the generation they belong to, remain a tenant in the eyes of the law. Whether a tenant has occupied a premises for 12 years or say it for 70 years, the law is now more explicit than ever. In the eyes of the Indian judiciary, possession is not title. Recent rulings from the Supreme Court in late 2025 have sent a clear message. The passage of time does not convert to rent received into a sale deal. Today, we look at why the doctrine of once a tenant, always a tenant is the ultimate shield for property owners. To understand the why, we must look at the Transfer of the Property Act, that is TOPA 1882. Under Section 105, a lessee is defined as a transfer of a right to enjoy property of a certain time in exchange for rent. Crucially, the law says the landlord, that is the lessor, transfers the possession but never the ownership. In legal terms, the tenant has a permissive right. This means you are there because the owner said you could be, as long as you're paying rents. Or even if you stop paying but started as a tenant, the law sees you as a tenant holding over. You aren't an owner, you are just a resident who is out of contract. This brings us to a crucial formal principle of Section 116 of the Indian Evidence Act. This is the doctrine of estoppel. It legally bars a tenant from ever denying the title of a landlord who put them in possession. You cannot occupy a house as a tenant and then claim in court that your landlord isn't the owner. In my opinion, this is the most powerful tool for landlords. It forces a tenant to choose either you are a tenant, you pay rent, or you are an illegal occupant with no protection. In Maharashtra, the law is even more specific. The Maharashtra Rent Control Act of 1998 provides tenant with statutory protection under Section 15 and 16. While this protects you from arbitrary eviction, it simultaneously anchors your status as a tenant. Moving ahead, Section 7 of this Act defines a tenant as someone by whom or on whose account rent is payable. By accepting this status, you acknowledge that someone else is the owner. In fact, if a tenant tries to claim they are the owners, they can be evicted under the principle of denial of title. If you deny your landlord's ownership, you lose your protection as a tenant. My professional take in this, the Maharashtra Act was designed to prevent homelessness, not to facilitate property grabbing. If a tenant in Mumbai or Pune stops paying rent and tries to claim ownership, they lose their statutory tenant status and become liable for immediate eviction. Under the principle of denial of title, now let's talk about the nail in the coffin. For these claims, in the landmark case of Jyoti, Sharma and Vishnu, Goyal, the Supreme Court dealt with a 70-year-old tenancy dispute. The tenants claimed ownership over adverse possession under the Limitation Act of 1963, arguing that decades of occupation had extinguished the landlord's title. The Supreme Court rejected this outright. The bench ruled out for possession to be adverse. It must be hostile. Since a tenant enters with permission, their stay can never be hostile. The court held that even non-payment of rent for decades does not make a tenant an owner. This decision is a massive victory for the scarcity of property rights, essentially declaring that no amount of time can cure a lack of title. To conclude, the Indian property law draws an unmistakable and absolute boundary between tenancy and ownership, a boundary that is neither blurred by time nor erased by long possession. Ownership flows only from the title, and the title flows only from a registered conveyance deed. Under Section 54 of the Transfer of the Property Act, the Supreme Court's 2025 ruling reinforces what the law has always maintained but has now conclusively settled a tenant's possession. It's permissive, never hostile, and therefore incapable of maturing into ownership. This clarity is essential for a healthy and a stable rental ecosystem. It reassures landlords that their reversionary rights remain secure, and it reminds tenants that statutory protection is a shield against eviction, not a stepping stone to ownership. A tenant is a custodian, not a claimant. Long-term stay may explain occupation, but it can never replace a title. If you are a landlord, ensure your agreements are properly registered. If you are a tenant, enjoy your home. But remember that a tenant receipt is a proof of residence, not a stake in the property. Thank you for listening to the Legal Insight podcast. I am Annkitta and will continue to bring you clear answers to complex legal questions grounded in law, precedent, and principles. To know more, reach out to us and contact on indialawllp.in.